Good morning and welcome to the second in this year's series of free bite-sized webinars for charities. The topic for today is an introduction to the Charities Act 2022. So what we're going to cover today is just shown on the slide there, on the agenda slide. Now, of course, I'm only going to be speaking to you for about 25 minutes this morning with a little bit of time for some questions at the end. So please do feel free to pop your questions in the question chat as I go through anything that occurs to you. This is a very new topic for everybody. So anything that you would like to ask, please do pop a question in for me. If I don't get any questions, then that's great. It means I've done my job very well. And I will be following up the webinar with a series of articles just to explain what we're going to cover today in a little bit more detail. The focus for today's webinar is very much on the practical implications of the Act. It is quite technical. There's been an awful lot of information out there about sort of headline statements about what the Act is going to do. And I think what we really want to achieve today is to give you a real sense of what it means in practice and how it will affect you, the people who are involved in the management and administration of charities on a day-to-day basis. So we're going to cover with just a very brief overview of the Act and why it's come about. And then I'm going to talk you through changes in the rules around amending governing documents, some key changes to the provisions affecting charities when they dispose of an interest in charity land. I'm going to talk about some new powers and changes in the rules affecting failed fundraising appeals. And I'm going to briefly mention a couple of other helpful new powers around making ex gratia payments and engaging trustees and connected persons for the provision of goods to the charity. Finally, we'll wrap up with a little word on implementation, but just to be clear from the outset, nothing that I'm about to talk about is currently in force. The Act is effective. It received royal assent in February, but the provisions are not yet in force, and we're waiting for the gradual implementation to take place. Okay, so to begin with, we're going to have a look at the background to the Act and how it came about. I'm not going to go into this in any detail, but just as a matter of interest for all of you, it's been a very, very long process. It all began really with Lord Hodgson's review of what was the Charities Act 2006 in 2011. Following that, there was then a Law Commission consultation which spanned about 3 years, looking at a whole range of technical issues in charity law. The upshot of that review process was the provision of a report, which is, as you can see, a very weighty document setting out various recommendations for changes to current law and attaching a draft charities bill. Now, that bill was broadly accepted and all of the recommendations were broadly accepted by government. There were some that were not accepted and there were some changes made to the bill, but that draft bill produced by the Law Commission is what has now made its way through Parliament and received royal assent on the 24th of February this year. The overarching aim of the Act and the entire consultation process was to reduce the administrative burden on charities and get rid of some of the unnecessary complexity and technical issues that affect the whole legal regime. Of course, there is a balance to be struck between reducing that regulatory burden and ensuring that we maintain appropriate regulation given the public interest in charities and the sector as a whole. Another key objective, particularly when it comes to things like amending governing documents, was to promote consistency across the different types of charities as far as possible. Those of you who've attended previous of my webinars may be aware that charity is a status and not a legal form. So there are lots of different types of charities out there: charitable companies, charitable trusts, CIOs, charitable unincorporated associations, royal charter bodies, etc., etc. As I've said, the implementation of the Act will be gradual, and I'll talk a little bit more about that at the end of the session. So turning first to the processes that are changing for amending governing documents. Now, if you attended my webinar last November or was it, I don't know if it was November, may have been earlier in the year, but last year on amending governing documents, this is now an update to that. So the rules are changing quite significantly. But all I'm going to be talking about today are the rules as they affect charitable companies, CIOs, trusts, and unincorporated associations. I'm not looking at the changes that have been made that affect royal charter charities, because I simply don't have time to cover everything in this morning's session. So I'm focusing on those 4 core legal forms that most charities tend to take. Now, as I mentioned already, the aim with this particular set of changes is very much to bring the processes and procedures very much into alignment. So the Law Commission was really looking at harmonising the processes and simplifying things to make it much easier and clearer for charity trustees to make changes to the governing documents as required from time to time. So what's been done is there's now been a wide power that is available to unincorporated charities, which was not previously quite so wide, which puts charitable trusts and unincorporated associations very much on the same footing as incorporated charities, so companies and CIOs. There are also now very similar processes for approving the amendments and greater certainty about when those amendments take effect. Of course, none of these changes are yet in force, but this is what is to come when they do become effective. So looking first at amending charitable purposes, this set of changes really does harmonise the process. Current law requires different conditions to be satisfied to change charitable purposes for companies and CIOs than to change them for trusts and unincorporated associations. There are different tests applicable, and there's not really a good justification for that. So the new rules will say that regardless of your legal form, whether you're incorporated as a company or CIO or unincorporated as a trust or association, you will need consent from the Charity Commission if you're looking to make changes to your purposes that are substantive. You don't need consent if you're not making a substantive change. Now, just as a word of caution, in the explanatory notes to the bill, it was made very clear that trustees should be careful when exercising this particular rule. It says trustees should think very carefully about whether even a small drafting change might affect the substance in even the most subtle of ways. So you do have to be careful when you're making changes to your charitable purposes. The other thing that this change means is you don't just have to look at when you're making changes to that particular clause of your governing documents. You also have to think about whether any other changes that you're making throughout the governing documents will have a bearing on the substantive purpose of the charity. So what we're looking at here is substance and not form. If you're changing, modernizing language, perhaps that doesn't make a substantive change, or you're updating cross-references or making other inconsequential amendments that don't substantively change your purposes, then that wouldn't be caught by the requirement to get Charity Commission consent. Now, in the explanatory notes to the bill, there are some helpful examples of this. So they clarify that, of course, a change in geographical area would be a substantive change. If your charity is set up to service a particular county and you wish to widen that geographical area to cover other counties, that is a substantive change. In terms of purposes where you say, for example, the charity has purposes to advance education, and then the objects clause goes on to explain the means by which you will advance education, there is a difference depending on how your objects are framed. If your objects state categorically that you are required to advance education by providing a school, then removing those words by providing a school would be a substantive change because your objects require the purposes to be carried out in that way. In contrast to that, if you had purposes that said to advance education, including but not limited to the provision of a school, then removing the requirement for the provision of a school wouldn't necessarily be a substantive change because you are not required to provide a school. The core purpose is advancement of education, and that is one of the many means by which you could achieve that purpose. So there is a subtle distinction there, and you have to look very carefully at the wording of the objects in order to work out whether a substantive change has been made. I appreciate that that still sounds probably quite technical. So if you're in any doubt about whether or not Commission consent is required, then it's probably better to err on the side of caution and submit an application to the Commission for consent. Now, the difference for unincorporated charities here is you do not now, once these rules come into force, need to go through the whole CPRE application process with the Commission, which is quite complex. Instead, you'll be required in the same way that companies and CIOs are to submit an application to the Commission, and we expect that this will be through the digital services platform where you go to do your annual filings and make changes to the names and details of trustees, for example. So you'd log into that platform, you would click on the button that says you want to change your governing documents, click on the option that it's to change your purposes, and submit the request to the Charity Commission for the change that you wish to make. Once you receive the consent from the Commission, you would then be free to go ahead and adopt that change. So it's a far more simple and consistent process for all legal forms. In assessing applications, there are now going to be consistent rules that the Charity Commission will apply. They will be looking at what are going to be called the similarity considerations. And essentially what this means is the Commission will look at the original purposes of the charity and think about the desirability for the new purposes to be as similar as possible to those original purposes, whilst taking into account the need to make sure that charities have suitable and effective purposes in light of prevailing social and economic circumstances. So those are the sorts of things that the Commission will be looking at in practice when they are considering changes to the objects. Until we have further guidance from the Commission about its policies for implementing those similarity considerations, we don't yet know what sort of approach the Commission will take, but at least it's now clear what it is the Commission will look at when considering applications for changing purposes, and the process to make that application will be the same across all legal forms that I've mentioned. In terms of other changes, so administrative changes to charity governing documents, well, at the moment, it's possible for all types of charities to make very simple administrative changes. There is already a statutory power for unincorporated charities, and companies and CIOs have that power as a matter of law also. But the existing regime does create some complexity for unincorporated charities, particularly in respect of things where it's not a change to the purposes, but it's also not actually an administrative change. The classic example being making changes to the sorts of situations in which trustee benefits can be approved. For unincorporated charities, there's not a power available for that sort of change at the moment. So unless there is an express power of amendment in the governing document, you're in a situation where you have to apply for an administrative scheme from the Charity Commission in order to make the change, which is burdensome. And again, it's disproportionate to require that of trusts and unincorporated associations where the same situation doesn't apply to companies and CIOs. So under the new rules, the current statutory powers are being entirely replaced for unincorporated charities with a brand new power that gives a very wide power to make administrative changes or any changes to the governing document of the charity, subject to obtaining the prior written consent from the Charity Commission in respect of 5 key areas, 5 key types of changes. Now, this is very similar to the existing regulated alteration regime that applies to companies and CIOs. And the first 3 of those 5 categories are the same. So if you're looking to make changes to your purposes, to trustee benefit provisions, or to the dissolution provisions in your governing document, you need Charity Commission consent. In addition, specifically for unincorporated charities, this new statutory power will require you to seek consent from the Commission if you're looking to change any provisions of the governing documents that affect any permanent endowment that's held, so provisions that have the effect of rendering particular assets or property as permanent endowment. If you're looking to change those provisions, you would need the prior written consent of the Charity Commission. Similarly, if you're looking to make changes to provisions in the governing document that give third-party rights, you would also need Charity Commission consent in advance. So those are the situations in which you'd need to apply to the Commission for consent. But again, the process is very much the same as it is now for companies and CIOs, where you would log on to that digital portal we expect. That will be what the Commission does to implement this. Log on to that portal, click the type of change you wish to make, and submit your application there. So the process will be far, far more straightforward. Once you've received the consent from the Commission to any changes you wish to make, the process for actually adopting those changes is also now streamlined. There's no change for companies or CIOs. It's still a special resolution, in effect, a 75% majority resolution of the members in a meeting. And there is already a subtle difference between companies and CIOs in that if you're taking a decision outside of a meeting for a CIO, then it has to be unanimous, whereas for companies, because of company law requirements, you can pass a special resolution as a written resolution with a 75% majority. So there is a difference there, and that's not being changed. That's a company law difference. But for unincorporated charities, the new power will allow you to do something very similar. So charitable trusts will be able to pass the changes, pass a resolution to make changes to the governing document of the charity using a 75% majority resolution. Now, this is, of course, in addition to any express powers of amendment, but if your charity doesn't have express powers and you're relying on that statutory power, you simply need to pass a 75% majority resolution to pass the changes. For unincorporated associations, because they have a separate membership, there is the step is that the members need to pass that resolution. But in that case, you'd start off with the trustees approving the changes by majority decision, as they normally would, and then putting those proposed changes to the membership of the association at a general meeting and asking them to either vote, in which case you're looking for a 75% majority, or simply asking if anybody dissents. And if nobody does dissent to the proposal, then it is deemed to be valid and passed. Similar to CIOs, for unincorporated associations, if you're looking to make a change outside of a meeting of the members, it does need to be unanimous, which is, depending on the size of your membership, might be difficult to obtain. So we expect that in practice, unincorporated associations will use the power in a meeting of the members. I said finally, there's going to be some helpful clarification about effective date of changes, and this primarily impacts CIOs. There's been quite a lot of criticism in the sector about the fact that changes to the constitution of a CIO don't take effect, regardless of what they are, until they're registered with the Charity Commission. Well, the Charities Act 2022 is changing that. So now, in respect of all legal forms, the resolution that you pass using the process I've just explained will be valid and effective from the date it is passed, unless it specifies a later date for becoming effective, or the prior written consent of the Charity Commission is required and you've not actually got that consent yet, so you're passing the resolution conditional on Charity Commission consent. For companies and CIOs, there is an additional hurdle in that if you're making changes to the charitable purposes, those are only valid once they are registered with either the Charity Commission for the CIO or Companies House for charitable companies. But that only applies in respect of changes to purposes because they need to be registered before they are effective. So again, simplifying the process and trying to, as far as possible, harmonise the position across all legal forms. Okay, land transactions. I'm just going to have a very brief talk through the key changes in legal requirements for land transactions. The aim here is to reduce time and cost for charities. So what has happened under the Act is that it's clarified the situations in which the Act applies. So when do you need to comply with the Charities Act requirements on a disposal or mortgaging of charity land? It also relaxes the rules around the kind of advice that needs to be obtained and creates a carve-out for short-term tenancies to employees. Finally, there's some greater certainty provided to third-party purchasers, which is also expected to reduce time and cost in transactions. Looking first at the clarification about what we mean by charity land and when the rules apply, the Charities Act 2022 clarifies that the provisions relating to charity land only bite when that land is held solely for one charity, so by that charity or in trust for that charity. So they don't apply if, for example, there are multiple beneficiaries, all of whom might be charities, and the whole of the land is being sold. So that's a really helpful clarification and resolves quite a lot of uncertainty in the sector about situations where a charity is only one of a number of beneficiaries, some of which might not actually be charities themselves. The new rules will make it absolutely clear that the provisions of Part 7 of the Charities Act 2011 apply where land is held solely by or in trust for a charity. The advice requirements, the key changes here are simply that it's broadening the category of people from whom you can obtain advice when you're looking to sell charity land. And this is in recognition of the fact that there is a huge variety of types of transactions involving charity land, and it's not always necessary or appropriate to obtain a qualified surveyor's report. So the new powers will allow the trustees some flexibility to consider who is best placed to provide the advice for the nature of the transaction and the risks involved. And the categories available include Fellows of the National Association of Estate Agents, Fellows of the Central Association of Agricultural Valuers, but also trustees, officers and employees within the charity who are suitably experienced. There's also a helpful removal of the statutory requirement to advertise in a manner advised by the surveyor's report, and there will be recommendations implemented to reform the requirements for what those advisors actually need to include in their reports to charities, but those recommendations have not yet been implemented. The short-term lease for employees exception is really helpful. At the moment, any lease to an employee would be a lease to a connected person and would require an order from the Charity Commission before you could proceed. This is now going to be relaxed slightly so that short-term leases of a term of a year or less can be granted to employees if it's for the purposes of a residential home, with in the same way that you would currently grant any lease of under 7 years. So you don't now need to go to the Commission for consent, you just need to obtain advice in that light touch manner that you would normally use for short-term leases. So that's a very helpful practical change that will be useful for charities with employees that provide accommodation. Finally, the benefits to third-party purchasers, which will have knock-on advantages for charities in practice, are around the statements and certificates position in the current legislation. So at the moment, in the transfer deed, so the document affecting the disposition of land, you have to include a certificate given by the charity trustees confirming compliance with the provisions of the Act. That certificate is only required in the document that actually affects the disposal. It isn't required in the contract, which often will precede that deed. Now that creates some uncertainty for third-party purchasers and mortgage and lenders in a mortgage situation. And what that can end up with is a whole process of extra due diligence by the third party to ensure that they have satisfied themselves that you've complied with the provisions before they will sign the contract. And that can add delays and cost to land transactions for charities. So under the new rules, that's all being simplified so that it's no longer a certificate, it's now a statement that is made by the charity of compliance, and that statement is going to be included both in the contract and in the transfer deed itself. The practical effect of this means that the statements you need to include in any transactions involving a disposal of an interest in charity land or mortgaging charity land will be exactly the same for all documents related to the transaction. That will provide comfort and reassurance and statutory protection to third-party purchasers and hopefully remove the need for those extra due diligence steps to be taken. Failed appeals. I'm going to talk very briefly about the changes here. This is quite a complex area of law, and I just want to talk and touch on the practical implications for you. Now, failed appeals essentially are fundraising appeals for a specific purpose or project where either you've not raised enough or you've raised more than you need. Now, it might seem a bit counterintuitive to think of raising more than you need as a failure, but the reason that these rules apply to those situations is because in both cases, you're in a situation where you've got funds that were given to you for a particular purpose, which you cannot use for that purpose. So what you need to do with those funds varies, and the current legal position is very complex. There's going to be a new power introduced, firstly, that where you have got a right to apply those proceeds, what we call CPRE, you will no longer have to apply to the Commission for a scheme. You will be able to pass a resolution yourselves and determine how you're going to apply those proceeds. If the funds to which that resolution applies exceed £1,000, you simply then need to submit that resolution to the Commission, and it won't take effect until the Commission has concurred with the proposed purposes for which you wish to use the funds. Now, that new power, of course, is only available when a CPRE occasion arises. Now, a CPRE occasion is simply an occasion where the law says you can apply those funds for a purpose as near as possible to the donor's original intentions. I will talk in a moment about the new relaxed rules that apply in a case of initial failure. So that's where insufficient funds have been raised for a particular purpose. The considerations that trustees must apply when using this new power are pretty much the same as what the Charity Commission would look at in assessing applications for changing purposes. So the desirability for similar purposes and the prevailing social and economic circumstances in society. Now, the relaxed new rules for initial failure are only applicable to situations where you have a fundraising appeal for a particular project, for example, replacing the roof of a church building, and you don't raise enough funds to actually go ahead with that project. What do you then do with the funds that have been donated? Now, the legal issue with this is that you need to establish what's called a general charitable intention in order for a CPRE occasion to arise. And this can be very difficult unless your fundraising literature has specifically said, if we don't raise enough, we will use the funds for X, Y, and Z. The new relaxed rules say that in those situations where you can't easily establish a general charitable intention, you may apply those funds CPRE if the court or the commission says that you can. If an individual donor has donated £120 or less, and that is the most that they've donated that financial year. If you've taken specific steps that you've agreed with the Charity Commission and you've not been able to identify any particular donors, or if you've got collections where it's difficult to distinguish between where those funds came from, so cash collections or proceeds of lotteries, for example. Now, in those 4 situations, that would give rise to a CPRE occasion for an initial failure, and you would then be able to apply that new power to resolve to use the funds for another purpose. I appreciate this is quite a complex area. We will be putting out an article that just explains it in a little bit more detail, but really this is one where we do have to wait to see what the Commission says in terms of guidance and process to see how all of these rules will be applicable in practice. So finally, I just want to touch on some other key changes. I don't have time today to talk you through them, but there is a helpful new power to buy goods from trustees and connected persons. This really extends the existing power to purchase services from trustees and connected persons under Section 185 of the Charities Act 2011. At the moment, you can only buy goods if that's in connection with the provision of services, and that's going to be changed so that you can just simply buy goods without it needing to be related to a provision of a service. There's also going to be a new power to make ex gratia payments. An ex gratia payment is a moral payment, a payment where you feel that there is a moral obligation to pay it or waive your right to the funds, but there is no legal power to do so. And what is considered small will vary depending on the size of your charity, and I've included on the screen a table showing the current thresholds, which will be subject to review over time. Finally, on implementation, when will the changes be effective? Well, as I said, none of them are yet in force. The provisions of the Act will be gradually implemented, and we're expecting the full implementation by autumn 2023. The changes will be implemented by a mixture of secondary legislation where it's required, but also changes in processes and procedures by the Charity Commission, updating guidance and also updating operational guidance and providing training to the Commission's caseworkers. That's everything that I have time for today. I have slightly overrun on my timings, but I have got a few questions, so I am going to just spend 5 minutes answering your questions. If you need to head off, please don't worry about staying, but I have got quite a few questions that have popped up, so I do just want to go through some of them for you. So just looking here, so a question about the time frame to expect the Commission to reply if you are looking to make changes to your purposes that you submit to the Charity Commission. Well, I mean, that's a very difficult question to answer because it will very much depend on the Charity Commission to determine what the timing will be. As a general rule, at the moment, all types of applications that we're submitting to the Commission, we're being told there is a 30 working day response time. So that applies to applications, for example, through the digital services portal by charitable companies at the moment to amend purposes or update trustee benefit provisions. Now we're hoping to see that delay, that timeframe reduce, but at the moment the Commission is advising 30 working days because of its workload. So the timeframe does fluctuate and it varies depending on how busy the Commission is. Hopefully, with the implementation of these changes, it will reduce the number of applications that the Commission is receiving in other respects and simplify things, which might hopefully free up some Charity Commission time, but that will be one to watch, I think. Somebody's asked a clarification question. When we talk about charitable companies, what do we mean by members? Are the members the same as the trustees? To answer that question, not necessarily. Charitable companies, CIOs, and unincorporated associations all have a two-tier governance structure. That means they have trustees who are responsible for the management and administration of the charity, and members to whom the trustees are accountable. In some charities, the people are identical, and it is possible for charitable companies and CIOs to have members and trustees who are the same. But usually, for unincorporated associations, there is a wide membership and a small executive committee, they're usually called, of trustees. It doesn't have to be the case, but that's more common. It is also possible for charitable companies to have different members to the trustees. So it's not necessarily the case that they are the same. To work out who your members are, you have to look at the register of members, and charitable companies and CIOs should maintain a register of members so that you've got that certainty. I've had another question about working for a charitable trust that doesn't currently have a dissolution statement in the governing document, and a question about whether Charity Commission consent would be needed to insert one. The answer to that is yes, you would need Commission consent. So under the new rules, if you were looking to make an amendment to your governing document to add a power of dissolution as a charitable trust, this is a situation where, yes, you would need the prior written consent of the Commission. So you'd apply, we think, is likely to be through the digital portal in the same way that a charitable company or CIO does. Okay, another question here. If you want to change your purposes and you're a charitable company, would it be good to do it now or after the rule changes come in? Now, that's an interesting question. I think for charitable companies, at the moment, the Commission will look at requests and consider whether it's expedient in the interest of the charity to make the change. So the new rules actually do tighten that up a little bit more, because they will apply some of these similarity considerations that currently apply under the CPRAISE scheme. So if you're looking to change your charitable purposes, then doing so now would be possibly a slightly simpler process. However, in practice, I think it is likely that the Commission will be looking at those considerations in any event. So to establish whether or not it's expedient in the interest of the charity, they would be looking at things like the social and economic circumstances that are prevailing, what are your reasons for wanting to make the change, how similar to your current purposes are the proposed new purposes. So in practice, it probably won't make a great deal of difference to the decision, and the process will be exactly the same for you now as it will be when the rules change. I think that's everything I have time for today. Thank you ever so much for those of you who've asked questions, and thank you very much for attending, and we will see you next time. The next session will be in May, and it will be my colleague Ed delivering a webinar on key considerations for commercial contracts, so top tips when you are negotiating commercial contracts. Hope to see you there.